Call the second case on this morning's docket, case number 117945, State of Kansas v. Grover James.
Mr. Chief Justice, and may it please the court, Kai Mann of the Appellate Defender's Office on behalf of the appellant defendant Grover James. May I please reserve 3 minutes for rebuttal?
3 minutes is granted.
Thank you. On May 8th, 2015, Rance Kindred hosted a birthday party in the basement of a formal wear shop in Wichita. The party was primarily attended by family, including Artadius Johnson, Mr. Kindred's son, and Leon McLennan, Mr. Johnson's cousin and Mr. Kindred's nephew. Mr. James also attended the party. Mr. Kindred introduced Mr. Johnson and Mr. James, which did not go well as the two had an acrimonious exchange regarding Mr. Johnson's treatment of Mr. James's nephew. Mr. James would testify that throughout the night, Mr. Johnson made faces at Mr. James indicating that he wished to fight. Early in the morning of May 9th, Mr. James left to go home with his girlfriend August Hughes, but then remembered that they had promised to help clean up after the party and returned. When Mr. James returned, Mr. Johnson confronted him aggressively, and Mr. James quickly found himself surrounded by Mr. Johnson, Mr. McLennan, and a third individual, Travis. As he was surrounded, Mr. Johnson continued speaking aggressively to Mr. James, while Mr. McLennan took off his hoodie as if he intended to fight, and Travis held his hand behind his back as if he had a gun. Mr. James then saw a silver flash coming from Travis's direction, and in response, Mr. James pulled his gun and fired 2 times, with the second bullet hitting Mr. McLennan in the head, killing him. Mr. James testified that as he fired, he was not aiming at anybody, and he also testified that he discharged his gun because he was in fear for his life. Mr. James subsequently went to trial on charges of first-degree premeditated murder and criminal possession of a firearm. Mr. James claimed self-defense at trial, and the jury was so instructed. The jury was also instructed on lesser-included offenses of intentional second-degree murder and imperfect self-defense voluntary manslaughter. However, the district court denied Mr. James of his requested lesser-included instructions of reckless second-degree murder, reckless involuntary manslaughter, and lawful act, unlawful manner, and voluntary manslaughter. The jury convicted Mr. James of premeditated first-degree murder, criminal possession of a firearm, and Mr. James appeals. Now, as the first issue on appeal that I would like to discuss today is that the district court erred in refusing to instruct the jury on lesser-included instructions of reckless homicide. Both of those requested instructions were reckless second-degree murder, which under the statutory definition is the killing of a human being committed unintentionally but recklessly under circumstances manifesting extreme indifference to the value of human life, and reckless involuntary manslaughter, which is simply the killing of a human being committed recklessly.
And what was the testimony about how many people were in the room and the size of the room at the time the shooting took place?
As far as the size of the room, there appeared to be a smaller room by the door that led to a dance floor with the bar over to one side, and then a pool area. As far as it did not appear to be a giant cavernous room, and I can't remember off the top of my head as to the size of the room, but as far regarding the number of individuals at the room, Mr. James would testify that Mr. McLennan, Mr. Johnson, and Travis were down at the basement at the time of the shooting, which would also match the testimony of Ms. Hughes, Mr. James's fiance, Ms. West, Mr. James's sister, and also Rance Kindred himself would testify that Travis was there the whole time and was there at the time Mr. McLennan was shot. Now, there were other individuals down in the room as cleaning up the party, but it's unclear as to who. Yeah, how many.
So we don't really have very clear evidence on how big the room was or how many people were in it
Correct,
at the
Your Honor.
time. Okay. And what is the evidence about? It comes from your client that he was surrounded by these gentlemen. There's 4 gentlemen.
That is, or the 3 gentlemen. Yeah,
And
Mr. Kindred
was sort of
may
on
or
the
may
periphery.
not have been. in the
Okay,
middle
so
of
we'll
it.
call it 3 plus possibly 1.
Yes.
That's his testimony. Does anybody else say that he was surrounded by those people?
Yes, Ms. Hughes testified to that, and Ms. West testified to that. And also, throughout the trial, there was some dispute as to whether or not Travis was there at all at the time of the shooting. However, Mr. Kindred would testify that Travis was there at the time of the shooting as well, which would further bolster Mr. James's testimony.
Present in the room.
Yes.
Kindred says present in the room. Okay. The state says that Mr. Kindred testified that the second shot occurred when your client pointed the gun at McClendon.
Mr. Kindred did not testify that. However, there was the video of him speaking to Mr. McClendon's family on the porch that was admitted. I believe that's exhibit number 46, in which Mr. Kindred does testify that, Mr. James pulled out his gun and fired. I do not believe that it necessarily said that he sighted and acquired a target and fired anybody in particular. But furthermore, Mr. Kindred also disavowed those statements he made in that video at trial, claiming that he was making up a story because he was being threatened by Mr. McClendon's family and was trying to mollify them so that they would not retaliate against him. However, here I think it's important to remember the standard review as a requested jury instruction. There only needs to be some evidence which would reasonably justify conviction of the lessers.
Let me.
Yes.
Talking about that, some evidence. What again? The evidence that he thought there was someone with a gun.
Yes.
Was that person identified who he thought had the gun, or was just some other person?
It was Travis.
Okay.
That came from more than just Kindred, right? There were several people that said they saw him with a gun.
Yes.
Maybe not at the moment of the shooting, but sometime in the evening.
Yes, at some time in the evening, Mr. Kindred said that, and Miss West also said that she saw Travis with a gun earlier in the night as well.
Thank you.
And ostensibly, he had his hand behind his back at
Yes.
the time of the fatal encounter. Correct?
Right.
Now, the first shot was into the ceiling.
Yes.
And was there any question as to whether that was just bad marksmanship or whether it was in fact a warning shot?
There was no testimony, express testimony that yes, I fired in the ceiling to warn as a warning shot. It was just more, I fired and I fired again, at least in my recollection of Mr. James's testimony. Furthermore, nobody saw, at trial, nobody testified to actually seeing Mr. James acquire a target and shoot. And furthermore, the video evidence never shows him acquire a target and shoot as well. We just see Mr. McClendon as the bullet hits him and fall to the ground. But the actual shooting occurred off the frame of the video camera.
So
At
Mr.
first-
James doesn't explain why he did shoot once into the ceiling, but then lowered his shot.
No, I think Mr. James's testimony was just that he was just firing. Quintessentially reckless act, firing into a crowded room. I think it was implied that he was attempting to scare these young men who he believed to do them harm. But no, there was no explanation. In fact, I believe, and I would have to check, and I can do that while the state attorney in their case, but I believe that he wasn't even sure that the first bullet went into the ceiling. He just fired his gun.
The first shot went in the ceiling. The second shot went just below the left ear of the victim, correct?
It did, yes. Yes, that is a correct statement. But again, I don't necessarily believe that proves intent, rather more just an unfortunate fact in this case, because it was entirely possible that as he fired, he just happened to hit Mr. McClendon.
And what was the distance?
The distance, I think it was at least 15 to 20 feet, but I would have to check that exactly sure in the record as well.
And there wasn't any testimony, as I understand it, about whether the victim was facing away or running away or any of that, or was there testimony about that?
I don't believe there is testimony about whether or not Mr. McClendon was running away. I mean, when we look at Exhibit 44, it appears Mr. McClendon was running away, but the only testimony that we have as far as where people were rushing to is when Ms.
When you
Hughes...
say the exhibit, are you talking about the video?
Yes, ma'am.
I've watched the video, and it just looks like he falls into the frame.
Yeah,
almost is propelled into the frame.
Yeah, and I couldn't tell if that was because he was running or if that was momentum
Yeah.
caused by the bullet
He's
trajectory.
clearly not conscious at the time he falls.
Clearly.
He falls very hard.
Yes.
Okay. So we can't really tell from the video.
No.
And you're saying there's no real testimony about whether he was attempting to escape at the time he was shot.
Right. Correct.
Assuming we find that you're correct and it was error not to instruct, why don't you go to harmlessness or harmless for us? Your client did receive a self-defense instruction.
He did.
And was told to consider along with the other as your. Why wouldn't in light of that be harmless error? The jury considered self-defense. Doesn't that kind of take the recklessness off the table?
No, I do not believe so for a couple of reasons. One, the jury was instructed on self-defense. However, they could have just simply rejected that. However, rejection of self-defense does not necessarily preclude a reckless firing. And two, this actually goes into issue 2 a little bit. As far as other lesser includeds connected to self-defense, the jury was only instructed on voluntary manslaughter and perfect self-defense, or an honest but unreasonable belief that deadly force was required, but they were never instructed on lawful act, unlawful manner, involuntary manslaughter, which requires that a reasonable and honest belief that physical force was required. Now, excluding Travis from the equation into whether or not he had a gun, the evidence was still there that Mr. McLennan and Mr. Johnson wished to do Mr. James harm. Ms. Hughes would testify that they saw a crowd of men. Ms. West would testify that she saw Mr. McLennan get into a fighting stance. Mr. James would also testify that Travis removed his hoodie as if he was getting ready to fight. And the video evidence...
Not Travis McLennan.
Oh, Mr. McLennan, I'm sorry, excuse me.
So you really have 3 guys
Right.
that are sort of in this group where there's apparently these faces made and whatever. Some indication. Didn't Johnson also testify that if he had a gun, he would have killed him first? Or something like that?
Mr. Johnson did not testify that he would, not to my recollection, but he did testify that he wished to do Mr. James harm at some point in the night, and that he likes to beat people up, and that's what he does, and that he wanted to beat Mr. James up due to the circumstances from before the night. But again, here, I believe that even if the jury was to reject the reckless theory, which I feel like firing a gun into a crowded room is the quintessential reckless fact pattern. I feel like that's the old law school chestnut as to what is reckless, firing a gun into a crowded room, which is what we have in this situation with no clear evidence of premeditation or targeting or intent. But furthermore, the under involuntary manslaughter, imperfect self-defense, a reasonable and honest belief that physical force was required. That instruction, I believe, fits this case perfectly. You know, we have testimony that Mr. Johnson was itching for a fight for Mr. James. We have testimony that Mr. McLennan removed his hoodie as if he was getting ready to fight. And we show on the video Mr. McLennan entering the basement wearing a hoodie, but not wearing a hoodie at the time that he is shot. Therefore, the jury could have believed that, you know, Mr. James was allowed to defend himself from a beating, but acted in an unlawful manner and using excessive force and firing the gun. Basically, I think that reckless second-degree murder, reckless involuntary manslaughter, unlawful act, unlawful involuntary manslaughter are 3 instructions that are tailor-made for this case, and it was an error for those not to be given.
You're about out of time on your opening argument. Can we talk about the right issue at the end?
Yes.
It seems to me that this case is distinct from Wright because we have a record that counsel recited at the time the continuances were obtained that he had consulted with your client. I don't think we had that in Wright.
No, but we do have that record, but we also have the letter that came prior to both continuances in which Mr. James expressed his...
How do those letters compare chronologically with the representation that counsel filed that said that the client had been consulted?
So the letter was filed on December 14th, 2015. The first continuance that was granted without his presence was done in February 16th, 2016, and the second was in March. So here even though Mr. McLennan or Mr. James, was not present, we do have his wishes being known on the record prior to those continuances being sought. And I'd also put that consulting with the client about something and doing their wishes.
The consultation was recited closer in time to the time that the continuances were granted, right? The problem here is we've got him expressing that at the beginning. Everybody has to acknowledge that. It's right there in black and white. But then he's represented later as having consulted, and then still later he says, I'm not worried about the time. You have a muddier record here, I think, than you did in Wright.
We do, but also in Wright, we believe that the court remanded to determine what the district court could have done at the time if Mr. Wright would have objected at the original continuance. And here, Mr. James eventually did give up, and allow this, but this was after 60 days of his 150 days had elapsed. And at that point...
I understand your argument.
Yes.
Okay.
If there are no other questions from the court, that's my prepared remarks.
All right. Thank you, counsel.
Thank you.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. And while as the appellee I do not have an obligation to do any factual recitation, I feel compelled to do so because the facts that I heard during appellant's argument very much do not match up with the facts as the jury found them in this case. Counsel's recitation indicated that this was a self-defense shooting, that the victim and two other people were surrounding the defendant, that the defendant shot essentially because he feared for his life, and indicated that there was no indication from any witnesses that would indicate that there was an intent to kill in this case. He made it sound like this was purely somebody firing randomly in a room with several people.
Mr. Maloney, tell me your best evidence that he pointed that gun at McLennan.
His best friend, who was throwing the party and who tried to testify for him at trial, Kindred told the police and told independent people who filmed this very clearly that what happened that night was that the defendant left the party to get his gun. He came back with his gun. He followed the victim and Johnson down the stairs. Johnson and the victim not only weren't doing anything aggressively, they hid behind Kindred to take cover and ask Kindred, calm your friend down. He's already pulled his gun by that point. Kindred is able to get him to put the gun away, thinks that at that point he has diffused the situation. As soon as Kindred lets him out of his grasp, the defendant then rearms himself, gets the gun back out, and then Kindred very specifically said in the statement to police that he saw the defendant aim the gun directly at the victim before firing.
That's certainly, or I would imagine, that's sufficient evidence to support the jury's conclusion that it was an intentional act. But when we're asking the question of whether a lesser included is factually appropriate, that's not the analysis, is it? I mean, don't we have to ask whether any juror could reasonably conclude from all the evidence that it was reckless?
You do look at all the evidence.
And so are you, when you got up and said you had a different recitation of the facts that the jury found, and I understand that, are you disputing the recitation of how the evidence came in favor of the defendant?
I am not, but I am relying on this court's case law that says that a self-serving statement of the defendant that there was no intent does not automatically require.
But we also have the testimony, the disavowing testimony from Kendrick, right?
Sure, you do. And I agree. You look at all of the evidence. And the case law says you look at to the extent to which other evidence repudiates the statement of the defendant. So here, yes, we have the statements from Kindred out of court, and then we have his testimony at trial, which differed. In his trial testimony, he said something that was completely opposite of what he had told police and what he had told family members in the aftermath of the shooting.
Well, just real quick to follow up on that. As I read the record, or at least what I can glean from it, the argument below was that the lesser included reckless instructions were not factually appropriate because the evidence showed that the firing of the second shot was intentional. Isn't that right?
I think that'd be fair.
That's not the right test, is it? That we're applying intentionality to the wrong act. Don't we have to apply intentionality to intent to kill, not intent to fire the shot?
Well, I think that.
And doesn't that make a real big difference in this case?
Well, sure, it's intent to kill, and I don't think that the court thought that just because I guess if your question is, did the court seem to believe that any intentional firing of the gun was enough to show intent to kill? I don't think that the record shows that the court was operating under that assumption. I think the court understood that it had to be intent to kill, and I think that's where the pointing of the gun directly at the victim would go directly toward intent to kill as opposed to firing a warning shot, which this court did ask opposing counsel about that first shot, which obviously went well above the victim or any other person and lodged in either the wall or the ceiling. Whether that was poor marksmanship or whether it was for whatever reason he decided to fire one warning shot and then fired a second shot. And clearly, I don't think there's any specific testimony that would tell us one way or the other whether that first shot was just bad aim or he decided to fire one shot and then immediately decided thereafter that he was actually going to try and kill the victim. But clearly that second shot, when you're aiming right at somebody, distinguishes this from a situation where somebody is truly just randomly firing a weapon, which is what counsel suggested.
You talk about blindly.
Right.
I have a question for you, Mr. Maloney. The colloquy with my colleague brings this to mind. You mentioned that you're relying on cases that say self-serving statements from the defense are inadequate to support a lesser included. But I think I also heard you acknowledge to him that Mr. Kindred backed off where he was before, intended to support the defense at trial. So that's not just the defendant, is it?
No, it's not just the defendant.
And once we have conflict, aren't we in a spot where lessers need to be given?
Well, again, I think you look at all of the evidence, the totality of the evidence in the case, and you determine whether, based on that, a jury could have truly reasonably found that this was not an intentional act. And I'd point out that even the evidence that the other evidence that
it was not an intention to kill.
Not an intentional killing, yes. And I point out that even the other testimony that he relies on, in addition to Kindred, is he points to the testimony of his sister and his fiance. And I would ask this court to look closely at that, for a couple of reasons. First of all, both of those women said that they did not see the shots. Second of all, one of the women, West, specifically said that she was not even in the basement at the time. And third of all, their testimony at trial, like Kindred, was very much in opposition to what they had said to police, where in their statements to police, they both said that Travis was not there, that Travis had long since left. So what we have is, yes, we have three witnesses who at trial suggested that Travis was in the basement and that something was going on.
But they shouldn't be believed, and is what you're saying, and isn't that a great argument to make to the jury?
I'm saying that when the totality of the evidence is considered, that a jury could not reasonably convict of a reckless crime when you look at all of that evidence.
So if this would have come up on, if they have given the lessers and he had been convicted of reckless second, we would be compelled then to reverse that because the evidence was insufficient to support a reckless second degree?
Well, and I know you and I have had this discussion numerous times. And
not just you and I. The whole court has had the discussion, and at present, it's gone back and forth, but at present, the majority view is the Haverline view that if the lesser could have, if the evidence could have supported a conviction of the lesser, it needs to be given. That's the current. And under that view, I understand the gatekeeping that that you're proposing and some of my colleagues propose, But under the other view, how can you say that there was not evidence that would have supported the lesser?
Well, I guess if that is the view that we're going on, I would argue that it would not support it if there's direct evidence that if there is overwhelming evidence that somebody aimed a gun at somebody and fired and hit him in the head. I would argue that there might very well be a legitimate argument by the defense in that type of a case to say, no, there is no evidence showing that this was a reckless killing. It would be, obviously the different situation that we're used to, where in that situation I can envision a scenario where a defense attorney would on appeal say, no, the evidence presented to the court in this case showed that if the defendant was guilty, he was guilty of an intentional killing. And where the evidence, when the jury has found that he did not intend to kill, that there was reckless conduct only, I think that probably a defense attorney would make that argument.
And we've had those cases, I think. We've had that case where the defense has challenged a reckless conviction, saying, no, it was an intentional act. And I think we found that, no, the intentional act isn't it has to be the intentional killing. And so, yeah, those have come up. But I'm just asking that if you have to weigh the evidence, there's competing evidence, and even if there's more evidence of intentional than reckless, if there's sufficient reckless evidence to support the lesser, we've said you have to give the lesser and let the jury make that determination of who to believe, how to weigh the evidence. And if we take that paradigm, which I understand you don't agree with, but if we take that paradigm, how can we say there isn't sufficient evidence for the lesser in this case?
I don't think I'm going to be able to give you a different answer than the one I just gave, which is that when the totality of the evidence is overwhelming, that there was not a reckless act, a reckless killing in this case, I don't think that would support the verdict. And I would respectfully ask this court to reconsider that paradigm. And I guess I'll give an...
Well, yeah, I was just going to ask you this because I've been on the other side of that paradigm, at least for the last decade, since 2008. But there never has been a majority of the court that has adopted what you're suggesting. And what is the discussion that goes on in jury instructions in light of this court's clear rulings on this, that it is the standard that Justice Johnson just talked about? Whether there's sufficient evidence to support the lesser. That seems to be the test. Why isn't that the test that's being applied?
Well, I can't claim to speak for the district court judges, but from my perspective, I think that the rational answer would be that if the court is reading the actual statute, which governs lesser included instructions, it talks about whether a jury could reasonably. And I think
that's been pointed out, like I said, for the last 10 years, and it's never has a majority of the court read it the way maybe you read it and I read it, but that's the majority of this court.
Explain to me why sufficiency of the evidence isn't reasonable.
Well, and I'll probably get myself in trouble for using the old language here, but when the test used to focus on whether the evidence was clearly of the higher degree, and I know that this court under the current majority does not prefer that test, but my perspective, and I think under that old test, the perspective was when the evidence is so clear that the crime was of the greater degree, then you're looking at a situation where it would not be reasonable to convict of some other offense. And to give a hypothetical, let's imagine that you've got a situation where somebody goes into a convenience store and there's surveillance video that shows that the person goes into the store, carefully positions himself, deliberately takes aim at the clerk, and fires a shot into his head while the clerk has his back turned. Now let's imagine that the defendant gets up on the stand and says, I didn't try to shoot anybody. My gun accidentally discharged. I was loaded. I have a concealed carry permit, and I accidentally shot him. It was purely an accident. Well, in a situation like that, would it be reasonable for the jury to convict of the lesser offense when you've got surveillance video that's directly showing you that everything that the defendant said is not true? And I would submit that even in that case, even if the defendant was able to get a witness to come in and testify in line with the defendant's theory when the evidence as a whole is so clear that that is not in fact what happened. I don't think that a conviction for reckless killing would be appropriate in that
But again,
circumstance.
would you at least concede that the argument you're making is the Haberline dissent? I mean, and I'm aligned with Justice Rosen on this question, but that's a minority view of the court.
My primary argument would be to try and convince this court to revisit that, but
And just to follow up, it looks to me like when the district court deciding this question rendered the court's ruling, the court was clearly weighing the evidence. The court said that it would be inconsistent for him to fire recklessly. The testimony of the defendant, who clearly said at least twice he was fearful of the group that he says surrounded him, it would be inconsistent then for him to fire recklessly. I mean, that is the gatekeeping function. That is the court weighing the totality of the evidence.
I guess when I interpret that comment, what I get there, I don't know that I would necessarily read the court's comments the same direction. I guess I would take that as the court basically saying, to the extent that the defendant is claiming that he was surrounded by a bunch of people and that he was acting in self-defense, then a self-defense claim would be inconsistent with unintentional.
Well, we know that defendants have the right to inconsistent defenses, but it seems to me this court is simply saying the evidence that supports a reckless firing has no credibility, given the totality of the evidence that came in. That's the district court's ruling as I read it.
And ultimately, I guess, regardless of whether the district court applied the right test or understood the right test in the correct manner, the ultimate question is whether their decision on whether to give the lesser was correct. Even if the court perhaps misunderstood the test, if this court were to find that its ultimate conclusion was correct, then clearly the decision would stand. And of course, I haven't even gotten in, and as I see my time is up, I'll just briefly get to
Why this is harmless or why it's
to
not?
our harmless error
And
argument.
as part of that, can you talk about the initial aggressor assertions?
Exactly,
Because
yeah.
I'm a little confused about the factual basis for that. If I'm remembering correctly, there was some statement that a gun could be seen on Mr. James in the video, either of him coming into the building, the outside video or the inside video. I've watched the inside video. I can't see one. So can you refresh me on that fact?
Yeah, I don't specifically recall that with respect to whether the
Okay.
video was said to have shown that.
Kindred said he pulled his gun out, but I don't remember. I don't remember where I saw that, but I thought someone had asserted that it could be seen on one of those videos.
And I unfortunately don't recall
Okay.
specifically, so the record will have to stand for itself. But you are correct that Kindred said that the defendant already had his gun drawn at the time that the victim and Johnson were hiding behind Kindred.
That was his initial statement, and then he backpedaled.
Sure.
So then, is that the basis of your initial aggressor argument?
Certainly to show that the defendant basically hunted these men down. He left the party to get his weapon. He came back. The victim and Johnson were sitting, minding their own business outside the club, which the video does show. They then see the defendant screech into the parking lot, and they immediately do the smart thing. They go inside to seek cover, not only by going into the club, but then by going behind Kindred, affirmatively asking him to intervene and calm down their friend, Kindred's friend. So yes, to the extent, even if this court or the jury were to have believed that once the defendant chased them down and pulled his weapon, that the victim and Johnson and the fictional Travis, who was not actually there, even if you were to believe that the three of them somehow approached him or surrounded him, the defendant had very clearly been the initial aggressor. He had set that entire chain of events in action by going down with his gun and surrounding and threatening two unarmed men who, near as I can tell, the worst thing that they did that night was possibly removing their sweatshirt. And essentially that's the defendant's claim, is that because they took off a hoodie and one of them was quote unquote puffing up, that somehow justified him in shooting them. And again, setting aside for a moment the testimony about Travis, even if you somehow believe that, the defendant put himself in the situation where he allegedly feared for his life by coming back to this club with a weapon and chasing these men into the basement, and then not stopping even when Johnson's dad intervened, and instead getting his weapon back out and firing and killing an unarmed man by shooting him in the side of the head. So yes, I would argue that even under the self-defense claim, that the initial aggressor law would negate that.
Do you have other harmlessness arguments you want to share with us, since we took your time?
I think in the brief I lined them out. I think that whether you want to call it the skip rule or simply say it's just another avenue of harmless, this jury was instructed on the lesser of intentional second-degree murder, and instead chose to convict of premeditated first-degree murder, which clearly shows that they found that this act was not only intentional, but was an intentional and premeditated killing. And I would certainly assert, as I did in the brief, that verdict is clearly inconsistent with any type of a verdict on a still lesser charge of any type of reckless conduct, or, for that matter, for the lawful act in an unlawful manner. This jury clearly signaled that they did not believe that this was an act of self-defense or anything other than a premeditated murder.
There's been an issue raised, I think, in the briefs on what our standard of review would be on the error alleged on these jury instructions. What's your position on that?
Yeah, our position is very clearly that this court has already told us multiple times, I think, that this is reviewed under the non-constitutional standard. There's the right to lesser included offenses instructions is a statutorily created right. And I think the case law does reflect that as a result that the non-constitutional standard applies, and we would simply assert that is well-reasoned case law and should be continued to be followed by this court. And as I pointed out in the brief, our ultimate position would be that either standard in this case, the error was harmless, but we would certainly ask this court to continue with the non-constitutional test.
Any more questions? Thank you, counsel.
Thank you.
Just like to make a couple of quick points regarding the evidence. Counsel has put a lot of eggs into the Rance Kindred video basket and contrasted his statements with police and what he testified to at trial. However, Mr. Kindred was not the only one to change his story at trial. In the affidavit on page 2 of volume 2, Mr. Johnson had told the police that Mr. McLennan removed his hoodie because he wanted to fight Mr. James at the time of the confrontation, but he also denied that at trial. So I think really the overarching theme here is that the evidence was of such that there is no clear evidence of premeditation, no clear evidence of intentionality, and therefore the instructions on the reckless theories and of the lawful act and lawful manslaughter should have been given, because the evidence would have supported it under a sufficiency analysis, which this court has held is the proper analysis for such claims when jury instructions are requested.
What about the argument that the finding of premeditation renders any error harmless?
I don't believe that this is a case in which skip rule logic would be supported, because the only difference between premeditated first-degree murder and intentional second-degree murder is premeditation. Premeditation is not a mental state. It is a temporal aspect to a mental state. But the jury was simply, in this case, left with the choice of either convicting Mr.
You're saying premeditation, the presence of premeditation does not exclude the possibility of a reckless act.
Correct. Because in this case, I think the jury was left with a position where they were stuck with either saying, yes, this was an intentional murder, or we have to acquit Mr. James.
I'm not talking about the intentional aspect. I'm talking about premeditation.
I do not believe that the premeditation aspect would necessarily preclude the reckless aspect of of this at all. And even if it does, I do not believe that the premeditation aspect of this would excuse unlawful act, or lawful act, unlawful manner, involuntary manslaughter, which also could have been given and also could be premeditated.
Isn't the problem, kind of the basic problem, logical problem with just applying the skip rule or something like it pretty automatically? That whatever the jury arrived at, your position is that was polluted by insufficient instruction.
Yes.
Okay.
Yes. I mean, and again, and not to say that the skip rule should be forever abandoned and never come again. I believe that the concurrence in Longoria makes a valid point that if the jury was instructed on first-degree murder, reckless second-degree murder, and convicts on first-degree murder, then reckless involuntary manslaughter would probably be excluded. But that's because of the logic that the jury had an opportunity to determine recklessness and passed on that opportunity. And this is just not one of those cases.
Right, and just to quickly follow up, it's true here that the jury had an opportunity to pass on the element of premeditation.
They did.
And chose not to.
True.
So I guess I'm just back to trying to figure out, is it possible for an individual to have premeditation and still act in a reckless manner? Could an individual walk into that basement with premeditation to kill, but then end up firing blindly or recklessly?
I would think that may be possible.
Because that's what you're arguing, right?
Yes, but also, I do think that when self-defense is in play, a lawful act, unlawful manner could certainly
You're saying
premeditated.
premeditation is certainly consistent with the imperfect self-defense.
With self-defense,
Right.
I understand that.
But
Yes.
not even if it's not with
Right. So I mean, even if this court doesn't believe that it would be recklessness, we still have a problem here where the jury should have received an instruction that they did not get.
The still lesser on involuntary because of the,
Yes.
yeah.
Well,
I think we
given,
understand.
given the discussion we had with opposing counsel, what scenario would a lesser not be appropriate in this case? I can't envision that once a person in your client's position asserts some sort of self-defense and it's corroborated by something, or maybe it doesn't even have to be corroborated by something, essentially a defendant gets every lesser that's requested.
In a scenario like this where the testimony is wide-ranging and
basically,
all possible.
it's almost automatic.
Yeah, of course. And I think that should necessarily be the case because that also affords the defendant the full opportunity of the reasonable doubt standard.
Because the Sixth Amendment charges the jury with the responsibility of
Correct.
fact-finding.
Any further questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.